Our next speaker wouldn't tell me what year she graduated from law school. She said she didn't want to date herself. So I'll just say it was after the Dolphins won their last Super Bowl. We go from there. She became she went to University of Miami School of Law. She became board certified in civil appeals in 1998. She has served as lead appellate counsel in more than 100 appeals before the 11th Circuit, the 3rd Circuit, and each of Florida's 5 district courts of appeal and the Supreme Court. She's handled appeals in all types of matter: medical malpractice, commercial disputes, products liability, and class action. Our firm uses appellate counsel in just about every case, and Kimberly Boldt is our go-to appellate lawyer. You want to have her, or somebody like her, so you don't end up in an appeal. So she also does what's called litigation support. So during the course of litigation, you pick up the phone and you tell her the issue that is before the court, and she is within 5 minutes on top of it. She knows the issue, she knows how to spot them. She'll give you a beautiful brief, one that you'd be happy to argue or have her argue for you. And on the appellate side, when you have a verdict that's successful, you need to defend it because Lord knows everybody's going to try to appeal it. She's there to write amazing briefs, and it's had great success, as mentioned before, in all the courts of appeal in the state of Florida. So it's my pleasure to introduce to you our next speaker on the law of closing arguments, Kimberly Boldt.
My notebook probably looks scary, but I'm an appellate lawyer and have to have law nearby, so it's not as bad as it looks. I want to thank Stuart for giving me this opportunity to talk to you all today, and I'm actually taking the place of Lincoln Connolly, who it's sort of appropriate that he's sitting at the courthouse waiting on a jury to come back. Have we heard? Do we know? He's still waiting. So he's at that anxious stage, pacing the halls, I'm sure, and doing what I've done many times with Stuart in many, many cases, and that's rehashing every word that was said and rehashing every event that occurred and trying to figure out what each of them is thinking and what are they doing and why is it taking so long. But it's when you do it with people who you enjoy working with, it's a really great process. The good news about being called in at the last minute to do this is Lincoln had done the outline. And it's a great outline, and it has a lot of wonderful information in it. And so we're going to go by it and we're going to use it. It's in your notebooks. I think it's under tab 6. And I'm going to actually ask you to turn to it just so that we can have a guide to go by and to talk about. As you know, I'm talking about closing arguments. We're going to talk about some of the areas that are the ripest points in time with which error can occur and how to preserve it and things of that nature. My take on closing arguments is that it is, we've heard from everyone before, and I agree with everyone that came before, that jury selection is probably the single most important part of a trial. It's really where you win or lose your case is in jury selection and making that process be what Stuart talked about, and getting people to open up to you and so that you can really figure out who these people are. I think that from an appellate perspective, when you sit back and you've had the experiences that I've had, which is, obviously I'm there for one of the parties, but because I'm not actually participating in questioning witnesses or doing arguments before the jury, I get to sort of have almost a third-party perspective on the case. And one thing that has become very clear to me over time is how important closing argument is, because it does provide the trial lawyer the opportunity to do what I think is the most important thing. And Stuart talked about this a little bit, and so did Roland. When you get to the point where you're going to turn this case over to 6 people that you don't know, that you've spent a very limited amount of time trying to get to know, and you hope that you've picked the right people, they ultimately go back into that jury deliberation room, and they become the advocates for your clients. There's no lawyer there, there's no judge there, there's no court reporter there. What you're left with are 6 everyday people who, throughout the course of a trial, if you want to use an analogy of an army, they're your army, and what you do through the course of a trial is you arm them with the ammunition that they're going to use to persuade one another in the jury room. So that's why I think closing argument is so important, because what you do in the closing argument is you pull it all together for them. And then in the space of an hour or 2 hours, however much time you have, you give them what they need to go back there and do the job for your client. And that's why it's interesting when I hear Rowley and Stewart talk about their trials and talk about the 2 instances where they've tried cases against one another and they've had hung jurors. I was a part of the first case. That was the Kamen case, a very, very interesting med-mal case that we tried. And we were in the Miami courthouse. I can't remember which floor we were on, but one of those floors where the jury room is right there. And we were waiting out, how the judges' offices are right here, and there's just these little waiting rooms, and then the jury room is right here. And we could hear them screaming at the top of their lungs at one another, and fighting. It was sort of hard to hear what they were saying. You would hear words here and there, but you couldn't make out like whole sentences. But it was, and we're all there together. We're there with Rowley and Stewart, and they were engaged in just a battle. And that's why what you have is you had a situation where you had 2 really great lawyers doing a great job, and you ended up with people in a jury room armed with the evidence that they needed to try to persuade one another. And that was the beauty of the whole process. I mean, obviously, both sides, wanted a verdict, but it shows that that's the nature of what occurs. And that's why I think I always say oral argument. That's why I think closing argument is so important. And that's consistent with some of the things that have even been recognized by the courts. If you look at one of the cases that Lincoln cites in his outline, I thought the second one was the best, where it talks about the fact that it would be naive to suppose that a closing argument does not have a profound effect upon the jury. These summarizing remarks often tie together for the jurors previously unconnected or seemingly irrelevant testimony and highlight those phases of the evidence considered most favorable by opposing parties. And so obviously we know the courts recognize how important closing arguments are, how important it is, and that's why so many cases turn on appeal on closing arguments. Before we get to the actual section on what constitutes a bad closing argument, what things you should stay away from, let's talk about the issue that Lincoln has in his outline second, which is time limitations. I don't recall in the trials I've sat in, and I've sat in many, many trials, ever having a problem where I felt like the trial judge was unfairly restricting time limitations. Obviously it happens because we've got reported decisions where people were given 15 minutes for a closing. So clearly it happens. When you look at these cases, it seems to happen more often in the shorter trials, and I think maybe the judge is thinking there it's a 2-day trial. What do you need more than 20 minutes for? So that seems to be where those types of errors occur. But the one case to have handy on that issue is the case that Lincoln cites towards the bottom of the page, the Byers case. That case actually sets out for you the 4-step process for preserving the error. Because this is one of those little weird areas of the law. If you don't preserve it the right way, you've waived it. So you have to ask the court for how much time you want. Let's say you ask the judge for an hour. He says, no, I'm going to give you 30 minutes. Well, judge, I need more than 30 minutes. Why? You have to tell the court why you need more than 30 minutes. You can't just say, I want it, then he doesn't give it to you, then you go do a 30-minute closing, and then you try to raise it on appeal that you wanted an hour. You haven't preserved it properly. So that's the good thing about this particular case, is it gives you the 4 steps, what the appellate court wants to see that you've asked the court for. You also have to ask the court for more time after you've done it. So he gives you 30 minutes. You say, I really need an hour, and here's why. Then he doesn't give you an hour, he still gives you 30 minutes. You do your 30 minutes, then you say to the judge, I'm asking you to reconsider, judge, I really need another 20 minutes, I really need that extra 30 minutes I asked you for to begin with, because I'd like to keep going. So that's the process there. The one really good thing about Lincoln's outline, and I would suggest this to all of you, if you go to trial, the lawyers that I work with, we go to trial armed with a lot of stuff, but one of the things is a trial memo notebook, a trial notebook that I have that has just law in it on different areas of things that seem to come up routinely. And Lincoln's memo is a great memo to just stick in your notebook if you have one that you take to trial with you, because it's just an easy reference tool. And that way, if you have this, you have that case there, it's an easy way to pull it up, because a lot of these issues, especially when it comes to preserving the error, of thinking about the 4 steps that I just told you about to preserve this issue, you may not have that right, in your memory bank to pull up. So that's why having a memo like this handy is a really good thing. And I think that's especially true with the next section of his memo, where he talks about things that can be said and things that can't be said. That's a good thing to review right before your closing argument. Okay, now we're going to move on to talk about this area of things that can be used, things that can be said, and things that can't be said. I think the most difficult problem, or the problem with closing argument, is that if you don't think through what your argument is going to be in advance with some specificity, I think that's where lawyers get in trouble. When I read the bad closing argument cases, and when you read through them, they begin to have themes, and you can sort of see what happens to lawyers in closing argument. You can also see where, in my estimation, a lot of the ones that go awry are where a lawyer gets on a roll. Because they'll quote in the, in the opinion, here's the closing, and they'll give you a nice sort of excerpt from it, and you can see them, and they get going, and they get a little bit further and a little bit further, and I call it, before you know it, you're doing 90 in a school zone, because you haven't thought through what your arguments are going to be. That's one of the things that Stuart and I, and I've done this with many other lawyers that I've worked with. The night before a closing, we talk about those things. We talk about how can we phrase this argument? How can we put this in a way that doesn't run afoul and doesn't get us into those danger zones? Stuart said to me numerous times, can I say this? And it's good to have someone to bounce those things off of, because otherwise what you do is you get into the passion of your closing argument, and you'll say something that'll go too far, and once you've said it, it's too late. So I would encourage you to do that with people who, if you have a second chair on the case, do it with them. Talk about what you might talk about in closing argument, and it'll help you stay within the right realm. I think that, we all know about the golden rule. We all know that, we're not supposed to ask the jurors to put themselves in the shoes of the plaintiff and things like that. When I read the golden rule cases, those are the ones that give me the most pause, because there's a line of cases that Lincoln has in here, and if you look at the 2 sections, if you flip between section 3 and 4, there's a section where here's the cases where they found this isn't a violation of the golden rule, here's a set of cases where they found that it is. And some of the ones in this first section where they have found that it's not a golden rule argument, I think are pretty close to golden rule arguments. So the problem that you have as the trial lawyer is if you get into what I call that danger zone, then you don't know what's going to happen on appeal. And I can't predict for you what's going to happen on appeal, because I can't tell you whether the statement that you made here, which is pretty close, is going to be interpreted as violating the rule or not violating the rule. Because then that's just up to 3 new judges who are going to look at it, and they get to decide the issue all over again, because really the whole question of whether or not we're going to reverse is it or is it not a golden rule violation. So, and I know I probably come at this from a more conservative perspective than necessarily the trial lawyer may, but I'm like, please, let's stay out of the danger zone, and let's rephrase the argument. That's why I go back to talking about it in advance. Let's say it this way instead of this way.